Lady, my lords, I've got 4 very quick points picking up on questions this morning. I promise my lone friend I won't be more than 5 minutes. So far as the questions about the guidance of the funded assistance, in the family court, we've been able to find a document, the family court guidance special measures, and that refers to assistance for parties or witnesses. It makes no reference to debarring or anyone falling into any other category. And it covers things like interpreters, intermediaries, and the other agency who I should have mentioned, Common Court. We couldn't find any equivalent for other divisions. So far as the Inheritance Act is concerned, Your Lordship asked me whether there was any ability under the Act to make conditional orders. Looking at Section 2, the powers to make periodic payments, lump sum orders or transfers of property deal with quantity and time, but don't have a facility on such terms or anything like that. So it does seem, looking at it calmly, that my instinctive guess that if you were trying to do that, you would have to do it through the medium of either a settlement or variation of a trust. Then you could create some terms that attached to when a benefit was actually conveyed or not. My learned friends have relied on a number of cases where orders have been made under Section 5 of the Inheritance Act for interim orders. My lady, my lords, we would say those aren't relevant. The criteria under Section 5 is that an application has been made, that an applicant is, and the expression is, in immediate need of financial assistance. So it's not adopting the language of the test for the application, namely financial provision or reasonable financial provision. It talks of something different, which is immediate need of financial assistance. It's explicitly where it's not possible to determine as yet whether an order should be made, and if so, what. And the other criterion is there's property available that forms part of the net estate. It's simply an interim provision that doesn't inform us about the content of an actual award at the end of the day. But it is right that the courts have used that on occasion to provide funds for legal representation. And also, we had a look at the Access to Justice Act, this question of the language around the uplift, and if you'll forgive me, I've got it on my phone. So, the Access to Justice Act 1999, as His Lordship rightly predicted, introduced by its Section 27, a then 58 of the Courts and Legal Services Act 1990, defining conditional fees, and its 58(2)(b), which says, for the purposes of this section and Section 58A, a conditional group fee agreement provides for a success fee if it provides for the amount of any fees to which it relates, to which it applies, to be increased in specific circumstances above the amount that would have been payable if they were not payable in those specific circumstances. So it's interesting that it uses the words a success fee if it provides for the amount of any fees to which it applies to be increased. So it's treating the success fee as a fee and as being the same nature as the base costs. And those are the only additional points I wanted to make.
Yes, my lady, my lords, I need to take you back to ground 1, I think, to begin.
Yes.
I think that the starting point on ground 1 is the breadth of the particular sanction in this case. It could not be more broad. The rules provide, as declared by Mrs. Justice that Mrs Hirachand was simply not permitted to participate in the hearing. And she also, under 8.6, was not allowed to rely upon written evidence at the hearing. And that is the context of ground 1 of the appeal. That is a very different thing to a Part 7 defendant who is debarred from defending or has had their defence struck out. And the case law that has been produced for the purposes of this appeal by the parties inevitably is based on Part 7 cases, because that's what there is. And I'll come back to the cases in a moment, but the context is important. In that context, I'd like to start by taking you through some of the items in the chronology and hopefully answering some of the points that were raised this morning. In the core bundle at tab 12, you will find at the very back of the bundle at tab 12, page 82, our chronology. From that, you will see this claim was issued as far back as November 2017. For the first year or so of the proceedings, nothing happened because there were numerous attempts by my client to have ADR. And so she asked the court to vacate the various directions hearings that were listed. Service of the claim did not take place until March 2018. The deadline for the acknowledgement of service and witness statement by the first defendant was the 29th of March 2018. And because she failed to meet it, that is when she became subject to the sanctions in Rules 8.4 and 8.6. And so, in fact, by the time this case got to trial in April 2020, the first defendant had been subject to those sanctions for over 2 years and had done nothing at all to remedy the situation properly. January 2019, she starts instructing Vickers solicitors, and they acted for her until they came off the record by Mrs Justice Leaven's order in November that year. The claimant cooperated with funds being released from the estate to fund those solicitors. There is no question in this case of the first defendant not being able to afford to pay for solicitors, because even if she did not have liquid cash to pay for them, she could always have gone to the estate and asked for money. And if necessary, and we're talking about an extreme case here, she could have gone to see a chancery master and got an order directing the personal representative to release funds as an interim distribution. So she had solicitors acting for her for about 10 months. During those 10 months, there was I'm going to say half-hearted attempt to get relief from sanctions by way of a witness statement that I need to show you, please, in the supplementary bundle. The tab 36 of this bundle. Page 266. Sorry, page 266. You'll see that Mr. Ingalls explains at paragraph 1 how he came to be instructed. It was through a support charity working with the London Borough of Ealing. He said, as a matter of evidence, that the first defendant didn't have resources to fund the claim without recourse to the estate. But the estate was a resource, I say, available. Now, then he goes on to acknowledge in paragraph 2 that she hasn't acknowledged service of the claim or provided any evidence. He says about 8 lines down on page 267 it would be, he says, most unjust for the court not to permit the first defendant to participate. The court can grant permission under 8.5. I think it should be 8.4, but in any event, we know what we're talking about. And I ask it to do so in the circumstances. He asked the court to consider it's not necessary for his client to make a formal application on notice. So that is the only instance when there was an attempt by the first defendant to get relief from the sanctions that she was subject to. I should also ask you to look at paragraph 3, where he refers to her deafness, where he says that he's had to resort to writing questions in large print on a computer screen to get an answer and to get instructions. He's got concerns about whether or not she can conduct litigation without the assistance of a litigation friend. As I submitted this morning, Leonard Jr. in fact wasn't present at the November 2019 hearing, one of her colleagues was, so I'm afraid it's third-hand information. But we understand that at that hearing, Mrs. Justice Lieberman was told that the solicitors consider the client to have capacity. And of course, those representing her now clearly consider her to have capacity to litigate. Again, for completeness, if you look at paragraph 7 over the page, in summing up his client's position is that the claim by my client should fail, because he says that there's been such a period of estrangement between my client and her father, the deceased. What happened after that was that my client agreed that the first defendant could have an extension of time for filing an acknowledgement of service and evidence in response. And so when it came to the directions hearing, which happened only 5 days later on the 18th of June, such an order was made, and the order of Mr. Justice MacDonald is at page 207 in the same plan. 207. Sorry, it begins at 206. And the order that's made at paragraph 5 here was by consent. And that was effectively relief from sanctions and gave the first defendant an extended deadline of the 22nd of July for responding to the claim. And then you've got the further directions about an FDR and disclosure and experts and so on. But going back to the chronology, of course, the first defendant did not meet that deadline. I should say she was represented by counsel at that directions hearing. And so, automatically, on the 22nd of July 2019, she was again subject to the sanctions of 8.4 and 8.6. And there followed a number of letters where, I don't think I need to show them all to you, but where her solicitors were reminded that she was subject to sanctions and asked whether or not she was going to make an application for relief. And at the very beginning of the supplemental bundle, in tab 1, there was an attempt a week after the deadline had expired, an attempt to file an acknowledgement of service. Out of time, the acknowledgement itself appears at page 4 with the box ticked saying I intend to contest the claim. And the covering email is at page 1, just says, "Dear Sir, acknowledgement attached." And clearly that was completely ineffective because she had no permission to file an acknowledgement so late. There were then some further letters which are in Mr Taylor's exhibit. Mr Taylor is my instructing solicitor, and he did a witness statement about these matters. I'm not sure time allows me to take you through the detail of it, but there was inevitably correspondence saying you can't do this, you're out of time, you haven't applied for relief from sanctions. And eventually the solicitors acting for the first defendant accepted that they would need to file a witness statement. An example is at page 284 in that bundle, the supplementary bundle. You'll see in the third brief paragraph on that page that they say that were we in a position to do so, we would of course file a witness statement from our client, i.e. in support of an application for relief from sanctions. This morning you looked at the witness statement of Mr Ingle in relation to his application to come off the record, and exhibited to that the 3 letters that he had written to his client from the 17th of September onwards. The page references are 300 to 302. And if I could just show you the most recent of them, which was at page 300, they're in reverse chronological order. Where he's sort of seeking instructions, but saying that he's in difficulty dealing with the case, in saying that she can oppose him coming off the record, but she needs to attend the court to do so. That, I think, is the last communication he had with his client, other than the letter that he wrote subsequent to Mrs Justice Leacon's order. Mrs Justice Leaven's order was very clear that they had to write to their client and appraise her of the position, and they confirmed that they had done so, and that's at page 15 in that same bundle at tab 6. Sorry for skipping around so much, but I should perhaps just remind you of exactly what they were ordered to say to their client. Back in tab 2 in that bundle at page 7, is the first of the orders made on by Mrs Justice Leaven, and she obliged vicars to do 3 things. One was write to their client fully explaining her position. That must have included the fact that she was subject to relief from sanctions, subject to sanctions, and wasn't allowed to participate in the trial, and couldn't provide witness evidence, but was entitled to attend. I mean, that would be a full explanation of the position. 2 was that they had to write to the manager of the care home and ask them to speak to Mrs Hirachand to explain the position. 3 was that they had to serve a copy of the order on each of the other parties, including their client. And they confirmed, as I said, that they had done that in the letter at page 15. So obviously from then on, Mrs Hirachand was representing herself. She did receive a number of letters from my instructing solicitors informing her that the trial was forthcoming, serving on her witness evidence, disclosure, eventually by email to the care home, the trial bundle, with a confirmation from the care home worker that it would be put onto a laptop and shown to her for the trial. she was informed at page 17 in this bundle that the hearing would be remote. Now, it seems that there was no formal notice of a remote hearing other than an email from the court. That isn't, I'm afraid, in the bundle for today. But I've checked the position in the last days, and that seems to be what took place.
Well, with all that was going on then, it would be astonishing if there had been.
Yes, indeed. Unimaginably busy week. So there were several communications with Mrs. Hirachand about that. The first one was on the 30th of March by email to the care home. That was about possible settlement, but you'll see about 4 lines down that it was said that the trial would take place via a remote hearing with the judge on the 23rd and 24th. At that stage, it was understood that she didn't want to attend court and wanted to negotiate. At page 24, there was another communication about the hearing by way of a letter to her dated the 2nd of April, serving disclosure on and saying that we awaited direction from the court for the hearing to proceed by remote hearing. And at page 46, there is another letter on the 20th of April, so only 3 days before the trial, confirming just below the second hole punch that the trial will be conducted via Skype. If you wish to attend the hearing, you'll need to arrange access to a computer. As agreed over the telephone today, there's an attendance note of the telephone conversation in the previous tab. Obviously, that was with the care worker. Miss Menon's email address would be used, and there's a page that a court bundle would be sent by email. So the first defendant was fully informed in the run-up to the trial of what was going to happen. She had the documents that she needed. Nobody suggesting she wasn't able to read. There were a number of options to her, open to her, both throughout the proceedings and at that particular point. She could have, but didn't, apply to appeal the directions of Mrs. Justice Leven and the declaration made by her that she was debarred from participating. She could have applied for relief from sanctions at any time before the trial. Importantly, because it's an answer to some of the points made this morning by the learned friend, she could have asked her son, who visited her, I think, every fortnight or so, or at least once a month, who was the executor of the estate, and who had solicitors acting for him throughout. Devon and Ottaway was the firm. You may see reference to emails to that firm in the bundle. She could have asked him to resile from his neutral stance and to defend the claim. It's very normal in 75 Act claims for an executor who is not a beneficiary to adopt a neutral stance and to leave it to beneficiaries to do the defending, particularly if there's a discretionary trust or minor beneficiaries and so on. But he didn't have to. He could have at any time decided he was going to defend the claim, and she could have agreed with him, as would be common in that situation, that he would be indemnified from the estate in relation to the cost risk that he would face personally as a hostile defendant. And there was, of course, as we know from the judgment of Mr Justice Cohen, cash in the estate to fund for any representation that he needed for that purpose. So at any time, if she either didn't wish to defend or wasn't able to defend, she could have got the executor to do the defending. And she could have communicated either to the court or to the claimant that she required special arrangements to be made for her attendance at the trial. And at no point did she do that. Even when she wrote her letter to the court that was sent to the judge on the 22nd of April, and the covering email is at tab 15. I think you looked at it this morning, page 49. It was sent in the afternoon of the 22nd of April. So, although the judge acknowledged in the judgment that she was profoundly deaf, he had no information from the first defendant as to the, I'm going to say this in a very non-medical way, but as to the precise nature of that deafness and exactly how she might be assisted to communicate with the court, or more importantly, given the fact she was sanctioned, to listen to what was going on. And there was no insensitivity to disability. Everybody was aware that she was deaf. But in order for the court to even consider what to do about it, it would have needed a medical report to identify precisely what the nature of the deafness was and what adjustments could be made. It certainly seems from the way that vicars had communicated with her, and indeed the way that the care worker communicated with her at the trial, as recorded in the judgment, I'll come to that in a moment, that she did use the written word to communicate. She used notes or things written on computer screens. There's no suggestion that she can communicate by sign language. And indeed, I understand from reading the Reece case that there are different kinds of sign language. So one has to be very precise about what means of communication would be suitable. So there was no way of knowing, either for the claimant to know or for the court to know, how to deal with Mrs. Hirachand's deafness other than by the way the judge did, because she herself had failed to provide that information to the court. On the question of who might pay for the report, if I can ask you to put aside the supplemental bundle for a moment and take up the authorities. The case of Reece appears at page 329. I think the learned friend may have mentioned this morning. At page 332 of that decision, there are some general observations about how to deal with deaf people within the court system. And I would highlight 3 lines up from the bottom, the word bespoke.
So what page are you on?
I'm so sorry, 332.
Thank you.
So that sentence just below letter H, communication between a profoundly deaf individual and professionals for the purpose of assessment and court proceedings involves a sophisticated and to a degree bespoke understanding of both the process of such communication and the level of character of the deaf person's comprehension. And then at paragraph 19 over the page, this has not been highlighted, I should confess, for you to read. But there's a quite useful explanation at paragraph 19 of the different kinds of sign language. And at paragraph 20, the Lord Justice McFarlane refers to another means of communication called deaf relay interpretation, which he explains what that is in that paragraph. He envisages at the foot of the page, I'm looking at the very last paragraph on the page, that the particular circumstances of the case will be fully addressed at the case management hearing. So at that stage, the court will direct how things should be done. And over the page, paragraph 27, he deals with funding and says that that needs to be grappled with. Beginning of paragraph 27, the issue of funding needs to be grappled with at the earliest stage, before the case management hearing and during the case management hearing. And then, just above letter C, he identifies 3 publicly funded sources of provision of assistance for a deaf person. The first is the Legal Aid Agency. The second is the Court Service, which provides interpreters in court. And the third is a local authority, which would provide an interpreter during meetings with social workers and any assessments. So the bespoke nature of what the court would need to do with an active party is important, because it's an obvious point, I'm afraid, but it hardly behoves the first defendant to be complaining that adjustments were not made when she herself had not informed the court what adjustments were needed. The court was left ultimately to guess and to try and work out the best way to manage things. I don't think it's really being suggested on the other side that the judge ignored the equal treatment bench book. The bench book, the 2018 version of which you have in the bundle, because that's what was applicable at the time of trial, has a clear focus, unsurprisingly, on litigants who actually engage in the proceedings and participate in hearings. And paragraphs 11 and 12 of our skeleton, forgive me if I can just give you references to the skeleton rather than go through the detail of it because of time. It identifies in a number of places that what it is aiming to do is enable people to participate. And again, it's a fairly obvious point, but it is striking that the word participation appears both in the sanction that the first defendant is subject to and in the engagement that she says now that she might have wished to have in the proceedings had adjustments been made.
Can I just ask you, does the bench book deal expressly with civil courts as opposed to family or criminal courts?
I don't recall that it does.
And just from more generally, can I ask you? My experience is greater of the criminal courts, for example. I haven't come across, for example, the use of an intermediary in a civil trial, but I could be wrong about that.
Well, the only kind of intermediary I've come across is the Mackenzie friend.
Yes, quite.
It's often a relation. It doesn't have to be anybody with legal training.
But that's not intermediary in the formal sense.
No. No. I should draw your attention, and this hasn't been mentioned at all in these proceedings yet, to a page in the white book. Just behind part 1 of the CPR, there is a practice direction at page 62 called Participation of Vulnerable Parties.
Sorry, page 62, the white book.
Yes. In my submission, this doesn't, it sort of mirrors what's in the Equal Treatment Bench Book. It is, as it says in the very first paragraph, focused on putting parties on an equal footing and enabling parties to participate fully in proceedings. It also provides that the parties are required to help the court to further the overriding objective. It identifies issues, and obviously these are short of incapacity, which is covered by Part 21. It identifies factors which may cause vulnerability. And anticipates at paragraph 6 that the court will wish to make directions at the earliest possible.
So you can have a ground rules hearing in civil cases.
Yes.
That comes as a considerable relief. Because otherwise...
I must admit, I've never been involved in a case where that's
happened
used, but it's there.
Well, perhaps you'll all use it now.
Absolutely. So one might think procedural common sense to have that practice direction, but perhaps more focus should be, or more emphasis should be placed upon it by us as practitioners. Maloney Jr. found yesterday, and I'm afraid this was supplied separate to the authorities bundle, a very recent case of the Employment Appeal Tribunal called Buckle. Has that reached information? This wasn't a case about deafness, it was about a lady who wanted to be able to give her evidence in the space of a day and didn't. It ended up being stretched over 2 days. And she said that reasonable adjustments had not been made for. The first thing to note is that paragraph 3, that she had not set out any assistance she required. And over the page at paragraph 4, she hadn't raised at a preliminary hearing what adjustments she needed. In fact, it was the respondents at paragraph 8 who first suggested that she might need a reasonable adjustment. But the claimant's solicitors wrote to the court so close to the hearing date that the court didn't look at the issue until the first day of the hearing. And it's worth noting at paragraph 17 that it's recorded in the third sentence that the parties provided a note of the discussion about whether or not the first day should be a reading day. Now, that's relevant because in this case, there isn't a transcript of the trial. The claimant is not, the appellant has not produced one. So you don't have in front of you a record of exactly what Mr Justice Cohen said in his reasoning about how to deal with the first defendant.
Is it your case that he did?
It's our case that there was some discussion between him and the care worker, as one might expect, to assess that she was happy to sit there all day. I think he says that in his judgment, and that just that she would be present and that she'd pass notes and so on. It's worth just noting, in fact, looking at the judgment for a moment, which is at tab 10 in the call bundle, that he says in paragraph 5 at page 69, says that she was in attendance throughout. Interesting use of the word attendance, considering what 8.4 says. She is profoundly deaf and did not hear anything that was said, but had the assistance of a workman at home who sat with her and passed her notes, so that she had at least some idea of what transpired. So the judge clearly satisfied himself that Mrs Hirachand did have at least some idea of what transpired. And then he goes on to say, I did not hear from her during the hearing. Now, we have no way of knowing what was in those notes. There's no evidence produced by Mrs Hirachand as to what she did or didn't understand. There's no witness statement from the care worker as to what she communicated to Mrs Hirachand, or indeed what she herself understood what was going on. So all we have is that the judge understood and found that she had at least some idea of what transpired. I mean, the words "at least" suggest she might have more than just some idea. But that is important, because it is not the case that she had no idea what was going on through the entire hearing, as may have been suggested by the learned friend. And going back to the Buckle case, if I may. I'm reminded by Leonard Jr. that I referred earlier to Mr Taylor's witness statement, and it's at page 149 in the supplementary bundle, and he says, as a matter of fact, that he recalls that at the start of the trial, Mr Justice Cohen inquired with the care home worker assisting the applicant, who he believes was called Alicia, on Skype as to who she was and whether she agreed to remain by the applicant's side throughout the duration of the day of the trial, to assist her to write down any questions the applicant may have during the hearing. The care home worker confirmed her availability until 5 p.m. The page reference is 149. The key points on the law in Buckle begin at paragraph 23. And there are repeated references on this page, I think I've counted at least 3, to substantive fairness being the guiding principle as to any issue about disability requiring adjustment. So he says at paragraph 23 that there may be circumstances where a party requires an adjustment that is of such fundamental importance that without it being made there can't be a fair hearing. In such cases, it's for the appellate court to determine as a matter of substantive fairness whether the adjustment requested was such that the failure to make it rendered the hearing unfair because the party was not able to sufficiently participate in the hearing and so was not given a fair trial.
Would you accept that profound deafness would be capable of being such a disability? I know you say it wasn't in this case for all the reasons you've outlined, but sort of clearing the decks, do you accept that?
If the first defendant were entitled to participate as an active party, then of course profound deafness would have to have probably I've already forgotten the name of it, but a particular mode of communication directed for by the judge, and if necessary paid for out of court resources, because that is essential for access to justice. But where a party, as here, has disqualified herself from the right to participate, I say that the situation is very different. And it is stretching things far too far to suggest that the court has some kind of duty to enable a party to hear and understand everything that happens on the day of the court hearing, in case she might wish to apply to participate, which seemed to be the sum of the first defendant's submissions on this point. The court, and this is clear from the practice direction we just looked at, and it's clear from the cases, has got to apply the overriding objective. On our side of the courtroom, in April 2020, there was a lady who had dire financial need, who had an income shortfall of some £1,300 a month, who had some psychiatric problems that she needed therapy for, who couldn't work because she didn't have the therapy. One has to ask oneself what would have happened if, as the first defendant seeks today, the judge had decided he had to adjourn so that a non-participating party could hear every single word that was said in the hearing. Now, if it's the case, and it's a big if it's the case that some kind of remote hearing could have taken place with appropriate equipment and personnel, that would have meant, presumably, an invasion of the care home that was sealed up because of COVID. We're told that she was in a care home that was restricted to outsiders. Or it would have meant adjourning to an in-person hearing in the Wells Building or in the Family Division, which, as we all know, could not have taken place for many months after April 2020. And there's the question as well of the risk to the first defendant's health of coming into London and travelling and so on, as well as the obvious prejudice to my client. And even if that prejudice could have been cured by a Section 5 application by my client for interim relief to tide her over until trial, how would the Section 5 application have been dealt with? It would have been at the same points over again, because it would have had to be a remote hearing. But the first defendant would have said, well, that can't happen because I'm in a care home and I need specialist equipment. So the prejudice to my client sits heavily in the scales in my submission against any question of adjourning the hearing. Now, I don't know whether or not that was going through the judge's mind, because there's no record of what he may have said about this on the day of the trial. But it seems reasonable to speculate that he may have considered that, and that the least bad option was what he did, which was that somebody familiar with the first defendant, who was clearly able to communicate with her, as we've seen from the correspondence, and willing to communicate with her and available to communicate with her, sat with her and gave her the gist of what was going on, so that she had at least some idea of what transpired, as he says. And whilst it's no part of my case to say that she could understand every word that was being said in court that day, that was a sufficient way of making a reasonable adjustment in the circumstances. It's striking as well that there's no real suggestion, I think, today that the first defendant would have made an application for relief, which would have had to be step one if she had been engaging in the hearing. She wasn't allowed to participate. She would have had to say, I want relief from sanctions so that I can participate. She's not saying that today. She was not allowed to start cross-examining or making submissions on the law or advancing factual evidence because she was subject to sanctions. And she didn't even try and do that. All she tried to do was to make written submissions to the judge 2 days before the hearing, which she did, and which he took into account, even though he didn't have to, and which my client didn't object to. So when one comes back to the question of substantive fairness, which is the focus of the court's approach in any case where there's an issue of disability of the party, the judge certainly, in my submission, achieved that. in the context of this particular case. Before I leave Buckle, may I just note at the end of paragraph 28 the following sentence. Where an adjustment is not requested or a request is not pursued with any figure, there may be little prospect of establishing that it really was so fundamental that without it there was an unfair hearing. That applies squarely to this case.
Well, I think we have to read.
I'm sorry.
No, I'll do. I think we're going to say the same thing.
Yeah, we need to place that in the context of the previous sentence, don't we?
Yes, indeed. Yes. It comes back to the question of information.
When you say a fortiori, if they're not even participating, I would have thought one would expect some indication of the nature of the disability.
Yeah.
The difficulty here may be, and as far as I can tell, none of the authorities has ever quite focused on this particular scenario. It's where you have a party who is debarred. So much of the language of the practice direction, for example, talks about a party. But it clearly contemplates things that you might do to facilitate their effective participation. But here, by definition, we're talking about a person who is a party, but they're barred from participating. And their only entitlement is to attend. In your written argument, you, I think, suggested that they were really analogous to any ordinary member of the public.
A spectator, if you will.
The spectator. I'm not sure I'd necessarily accept that.
Can I draw an analogy with a sporting event? If I go to Centre Court this afternoon, I'm attending Centre Court, but I'm not participating in the match. I don't have to understand.
Yeah, but you don't lose the prize money if it goes the wrong way.
But I don't need to understand. My point is, I don't need to understand exactly what's going on to be in attendance. There's clearly a difference between attending. Literally, I think the dictionary definition is being present at, and participating. One might wonder why a party is entitled to attend if they can't participate. What does it mean to meaningfully attend, to use my own friend's expression? Well, one meaning may well be that if hearings are in private, then the party is entitled to attend.
Yes.
There's no guidance otherwise as to what the real meaning, what the writers of the rules
But I would have thought, but I'd have thought in this case, if, for example, the defendant had said, I really would like to have somebody who can assist me, had given advance notice, these are the dates that they can do it, can we accommodate it so it fits my dates? One would expect the court to make an effort to do it. One wouldn't expect the court to make an effort to do it for somebody who says, I'm just coming in off the streets and I'd like to hear what's going on. So to that extent, they're not quite in the same position, are they?
They're not. I'm thinking though about, in fact, in this particular case, one has to go right back to the directions made by Mrs. Justice Leaven, which directed that the trial be fixed by convenience to the parties other than the first defendant.
No, I understand that. I'm just trying to draw the distinction between this party, who is, as I'm sure, as my friend says, or Justice Singh says, it's not quite the same as somebody who's simply viewing the event. They still have an interest in the outcome.
Yes, they do. I think it's impossible to say they're exactly on all fours, but somebody who's, I'm probably repeating myself, somebody who's displayed no appetite to engage at all in the proceedings and has been subject to sanctions and so on, they cannot say that they're in the same position as an active participant. And on the question of justice and the overriding objective, it would be extraordinary for somebody who's been subject to sanctions for the best part of 2 years, other than that small moment in July, between June and July 2019, when she had the chance to meet an extended deadline. to suddenly say on the day of the trial that the case should be adjourned and that she should have relief from sanctions, that adjustments that she hasn't informed the court of should be made, and so on. It's just too late. And I just want to be clear: nobody is suggesting that had she done it at an early stage, that she shouldn't have had all proper adjustments made. But she is, to use an obvious expression, the author of her own misfortune. Can I move on to the question then of, I think I've dealt with participation. Sorry, I think I'm just trying to speed up by skipping some parts of my notes that I've already covered.
Take your time. I think we're probably nearly at the end of your submissions on ground one, are we not?
I'm glad to say I am, yes. May I finish them?
No, of course you must. Of course.
There needs to be, in my submission, a bit of a reality check in this case. The appellant's asking the court to say that the trial should have happened only after COVID restrictions had been lifted, and she could have left her care home and somebody funded some specialist communication services. I mean, that is part of her written case, that the trial should have been adjourned and that these adjustments should have been made. Apart from the question of who would pay the cost of the adjournment, bearing in mind that Milena Jr. had done all the preparatory work by that stage, and the prejudice I've already mentioned to my client, and the Section 5 application, what would have really happened? Would the appellant have gone and got fresh legal representation, which she could have done? Would she have had a person communicating word for word what was going on in court and simply sat and listened, and the result would have, in my submission, been exactly the same based on the evidence the judge had? Her case appears to be not that she wished to apply for relief from sanctions and would have done, but that she simply wanted to be able to listen. She doesn't even suggest today, at the end of this morning's submissions, that there should now be a retrial of the whole case. So it's no part of her appeal now that the result in the case would have been different. It's hard to see what the point of the appeal is in that case. She suggests that there might be a different order on costs, but that's impossible to understand. The judge would find, or would have found, exactly the same facts. So there's a successful claim, and taking a fairly large proportion of an estate, it's a successful claim. The successful party has made 3 settlement offers. That's recorded in open correspondence.
Are they in the bundle?
Yes. The offers themselves aren't related, but the reference to them is. That's at page 71 of the supplemental bundle. No offers had been made by the first defendant. That's the same page reference. There's no suggestion, there can't be any suggestion, that my client has misconducted herself through the hearing. The only person about whom misconduct points can be made is the first defendant, who's failed to engage. It was inevitable. In fact, although one can rarely be certain about things in civil litigation, one can be certain that a costs order would have been made in my client's favour at the close of trial in this case. she had a successful claim, she had engaged or sought to engage in ADR, and the first defendant had debarred herself from participating in the trial. It is inevitable there would have been a costs order in my client's favour. There's no transcript of the costs hearing on the 7th of May 2020. The appellant has not produced one. The suggestion that she, even though she was debarred, that she should have been entitled to participate in the costs hearing is not consistent with the only authority on this point. And there isn't any detailed discussion in that authority, but in Michael and Phillips, which is in your bundle of authorities, it's at page 277, and on the final page, if you return the light of that decision, at page 281, the judge, Mr Justice Sewell, in the Queen's Bench Division, found that as to costs, in principle, I consider that these are part of the claim. Because the parties agreed that the costs could be placed in a separate category, he actually did, in the end, enable the debarred party to make cost submissions. But as a matter of principle, he considered that they're part of the claim. And that, so therefore, the debarring order made in that case, it was a Part 7 case, that the claim may not be defended, included not making submissions on costs. The first defendant was given the cost schedules a couple of days in advance of the cost hearing. She did in fact make submissions about costs, which she looked at this morning at page 103 of the bundle. The executor didn't look at this page. If I can ask you to turn back to page 105 in the supplementary bundle, the executor actually agreed a costs order in principle against the first defendant. A draft order was circulated by Malone Jr. and that the covering email is at page 105 behind tab 31, and the draft order is immediately behind it, and you'll see at paragraph 3 of the draft order there was a provision for the first defendant to pay the claimant's costs summarily assessed.
Sorry, so just I'm clear, was this a draft that was put before the judge for the hearing?
Yes. But the order that was made was extremely similar to the draft. I think figures were simply inserted.
So obviously the executive hadn't agreed the figures.
No,
It agreed the format of the draft order.
it agreed the principle of the liability costs.
Yeah, understood.
I think I'm largely finished on round 1. There were some points made this morning, but which can I just sort of tidy up a couple of very brief points. Firstly, as a matter of fact, there was a psychiatrist report, and it's actually referred to in the judgment. Your ladyship, I think, is ahead of me. It's at paragraph. It's referred to in the judgment at paragraphs 11, 19, and 31 to 35. The first defendant appeared to be saying this morning, in response to a question from Lord Justice Singh, that the court has a duty to ensure that the first defendant could understand what was going on, not in the sense of communication and being able to hear, but in the sense of understanding legalese or understanding exactly what was going on as a matter of substance in the proceedings. Now, many litigants in person don't have that. I mean, with the best will in the world, they don't always have that.
Many lawyers don't.
And it simply isn't the case that the court has some duty to ensure that any party has a duty to understand the substance of what's going on, beyond trying to assist the litigant in person, but sometimes it's just impossible. And there are all the schemes of the CLIP scheme in the Chancery Division, for example, the pro bono unit, and everybody does the best they can to assist. But there will inevitably be situations where somebody who may be elderly and not used to litigating, why would they be, simply doesn't understand the detail of what is going on. And that's just reality of life within courts. That's why people have legal representation if they can afford it, which the first defendant could. But the idea that the court has a duty to start funding, particularly specialist people, to explain the substance of what's going on is, in my submission, beyond what the Equal Treatment Bench Book or any of the other similar provisions is trying to accomplish. It's a very different question. May I just turn around for a moment? Maloney Jr. reminds me that the executor was encouraged at the cost hearing to make some submissions, and I understand that he did so, but we don't, again, have a transcript of that. I think, unless I can assist you further, that's it on ground.
No, thank you very much. That's most helpful. Well, shall we have a short break before you move on to ground two? So, 25 past.
You said for tomorrow. Is that the time finished?
Yeah, finished.
I've got 73 another course. Okay, so I don't need to keep going. See you later.
Yeah. Scott is still sitting, right?
Sorry?
Scott. Scott. Scott, is this his name?
Sorry?
He's a dental.
Scott, yeah. Paula's going to give her a break. She's seen Lucy.
Oh, Lucy's finished.
Lucy finished at 12,
Yeah.
but I'll put her in Pauline's course.
Yeah.
So she's in 63.
Yeah,
That's the
she's finished as well.
Oh, she?
Yeah.
Oh,
She's definitely a good butcher. So.
oh, okay, I'll be checking the phone.
Yeah.
Yeah, I'm not saying
Yeah.
to.
Oh, okay.
Oh, okay. I think 73 is still sitting, but I'll put those in for tomorrow. See you later.
Yeah.
Oh, she didn't get it today. Oh, she left it on.
Yeah, she left it on there.
Oh, I just think, oh, I think it's... Right, darling, I didn't do that.
Yeah. So Miss Scott's sitting.
I think it's on.
Yeah. Scott as well.
I'll start.
Yeah.
Okay.
Yeah.
See you later. Thank you.
Round two.
Round two. A couple of general points first, if I may. In virtually every judgment that's given in cases under the Act, judges note that previous authorities don't help them very much because every case is so fact-specific. I think frustrating as it can be for judges and practitioners that precedents are of limited use because of that. I would submit it's one of the virtues of the Act that it enables the court to tailor-make the relief to the particular claimant and facts of the case. And that is one of the purposes of the Act, is to enable the relief to be tailor-made. That was expressly considered as one of its functions. Some of the wording in the Act is broad because it's there to achieve that purpose, such as the word maintenance that we'll look at in a moment, such as the expression financial needs and financial resources. The appellant today is asking the Ladyship and the Lordships to insert words into the Act which are not there in order to impose some restrictions on it, as well as to undo many years of practice in both the Chancery and Family Divisions, and indeed in the County Courts, of treating the funding of costs as part of the claimant's financial needs. And to be absolutely clear, it's no part of my case that either in all cases where there's a CFA, a success fee must be regarded as part of the claimant's needs, or that 100% of the success fee is the correct contribution towards the claimant's reasonable needs in every case. As with any item of financial need, generally produced on a detailed schedule of expenditure and liabilities, the court goes through each one and decides whether or not a claimant really needs to, in terms of prospective expenditure, spend £20,000 on annual holidays and all the rest of it. And in terms of liabilities, the court will scrutinise whether or not a particular liability was reasonably incurred, or indeed is an immediate liability. So quite often there may be a family loan made to a claimant, which the court may decide is not immediately repayable because it's not made on commercial terms. So the court will scrutinise each and every one to decide, firstly, whether it's a true liability that's immediately payable, and secondly, whether the quantum of it is reasonable. And that's exactly what the judge did in this particular case, and to the extent it's relevant, indeed the judge in Bull and Denton did. But in this particular case, the judge looked at the claimed success fee, which was 72% of the base rate fees, and decided that because he thought it was, I think, reading between the lines, fairly obvious that the claim had merit, that a 25% success fee was more appropriate, and also as part of the balancing that he achieved. So it is part of the court's approach to a success fee under a CFA as part of financial needs that it will scrutinise whether or not it needed to be incurred and whether the quantum of it appears to be reasonable. There was a finding of fact in this case, at paragraph 55 of the judgment, that the claimant had no other means of funding other than by CFA. So that is an inescapable finding of fact in this particular case. There is the first defendant has talked about policies. There is a policy here of access to justice. That's a policy concern. To the extent that the court should be looking at public policy, that goes into the consideration. In my submission, a success fee is incurred as part of prospective funding of a case. It will be incurred, if not at the very outset, generally at a fairly early stage, or at least that the contract will be entered into at a fairly early stage. The costs order that is made at the conclusion of a trial is retrospective in nature. The court is considering, under the CPR, the conduct of the parties, the extent to which a party has been successful on a particular issue, who has won overall, and any relevant ADR issues, mediation or settlement offers. That is all retrospective. At the date of the hearing, the court has got to take into account, under section 3, subsection 5 of the Act, the facts as known at the date of the hearing. And at that point, the judge will not know exactly what the cost position is, but will know, because the judge will be deciding whether the claim succeeds at all, will know whether or not a success fee has been triggered. And as happened in this case, the judge can inform themselves by asking the relevant party what the terms of the CFA are, and possibly even demand to see a copy of it. That, in my submission, goes some way to alleviate the concern that was expressed by Mr Justice Briggs, as he was, in Lillyman in the costs decision, which is at page 41 of the bundle, that a needs-based calculation carried out in the 75 claim might be affected by cost shifting. The inevitable concern is that if a party has had to incur legal costs in order to get a successful outcome, that the very careful calculation the court's made of the claimant's financial needs is suddenly undone by costs. Now that is a tension that's simply inherent within this jurisdiction, and it's for Parliament to resolve. The court simply can't resolve it, because the court has to approach these cases within the tram lines of what is in the 75 Act. It can't start imposing restrictions on the wording of the Act. And this distinction, going back to the prospective funding versus retrospective cost assessment, was in my submission drawn quite firmly by Mr Justice Mostyn in the case of Rubin, which I'd ask you to turn up, please. It's in the authorities bundle at page 324. So the first page is at 319, but if you would turn please to page 324. This was an application for a legal services payment order under the Matrimonial Causes Act, section 22ZA, to cover costs incurred in financial remedy proceedings. And Mr Justice Mostyn, I should say it begins on the previous page at 323, sets out some equitable principles at paragraph 13. The first two of which are perhaps not so applicable here, but at little 3 at the top of page 324 in the bundle, he says that where the claim for substantive relief appears doubtful, whether by virtue of a challenge to the jurisdiction or otherwise about the subject matter, the court should judge the application with caution. The more doubtful it is, the more cautious it should be. I should preface this by saying he does say that this is all relevant to Section 5 applications in the Inheritance Act.
Mr Justice Mostyn does.
Yes. I'm going to take you to... Sorry, if I... he says that later on.
All right, sorry, I won't take you out of turn.
I'm so sorry, I hope I'm not being unclear. At little 4 there, he says that the court can't make an order unless it's satisfied that without the payment, the applicant would not reasonably be able to obtain appropriate legal services for the proceedings. Therefore, the exercise essentially looks to the future it's important that the jurisdiction is not used to outflank or supplant the powers and principles governing award of costs in CPR Part 44. It's not a surrogate inter partes cost jurisdiction. It should only be awarded to cover historic unpaid costs, where the court is satisfied that without such a payment, the applicant won't reasonably be able to obtain future legal services. It's over the page, Milady, at paragraph 14, where he notes that the statutory provisions don't extend to the Inheritance Act. But over the page again, at the end of paragraph 15, at the top of the page by letter B, at the beginning of paragraph 15 on the previous page, he says that the principles set out in his long paragraph 13 ought to apply where an order is sought under section 5 of the 75 Act. Now, my point about
I was
this...
going to say, there's nothing to do with success fees, which
My,
don't exist in family.
Lady, yes, but the point I seek to draw from this is that in his little 4, he is drawing a distinction between the as I've used the wording, the retrospective assessment that may be done of costs within the CPR and the facilitation of access to legal representation that the court can provide by way of an order, either in this case by the LSPO or under section 5 of the Inheritance Act. And that is in my submission at the heart of this, that of this appeal, that this distinction does need to be drawn. The Act itself provides in section 5 that interim relief can be provided to a claimant. It is well established now in both the High Court divisions, Chancery and Family, that relief to fund legal costs is fairly standard as interim relief. The cases are referred to in our skeleton argument, but it's worth noting that if I could ask you to look at the end of the authorities bundle at the actual statute. At page 493. This is what provides the jurisdiction to grant such interim relief under the Act, section 5. Malone's friend showed you this morning, that there's got to be, at A, the applicant's got to be in immediate need of financial assistance, and at B, there's got to be property in the estate that's available to meet that need. And you will note at subsection 3, further down, it provides that in determining what order, if any, should be made under this section, the court shall, so far as the urgency of the case permits, have regard to the same matters as those to which the court is required to have regard under section 3 of the Act. So the court, as well as considering A and B at the beginning of subsection 1, has got to have regard to all of the matters in section 3, which it will eventually be considering in the trial of the claim. And that is important, not only because it's relevant to merits, but because it's a much more holistic exercise than just saying, does the applicant need money? The court is able to form, or has to form, if it can, an early view about the outcome, and will readily, especially in spousal claims, provide interim relief for a claimant and acknowledge as it does so that interim relief may not end up being recoverable if the claim fails. Now, it's relevant for this appeal, I submit, that not only that jurisdiction exists because the Act is enabling prospective funding of 75 Act proceedings, it is giving the claimant an advantage in some ways by doing that, because a defendant can't apply for an order under section 5. A defendant's only recourse, as in this case, say to the personal representative of the estate, I need some funding from the estate, I need an interim distribution to fund my legal costs. A claimant can go straight to the court. And in an application under Section 5, the claimant has got to provide evidence to the court about other means of funding the case. And in particular, can the claimant obtain some form of CFA or funding from a commercial litigation funder. And the court will take that into account in making a decision. If conditional fee agreement success fees were not recoverable as part of relief under the Act, as part of reasonable financial provision, it's inevitable that there would be far more Section 5 applications, because many claimants under the Act are impecunious and can't afford their legal fees. Again, relevant to public policy, to the extent one needs to have regard to that, that would mean more expense for the parties, consumption of more court time, and ultimately more risk to defendants if the interim provision can't be recovered because the claim ends up being unsuccessful.
Just so I'm clear, you're not saying that under Section 5, on an interim basis, that the court would give them their success fee?
No,
you're saying that what they'd get would be...
The court couldn't do that.
No, exactly.
Because it wouldn't know whether or not
exactly.
it was triggered. I mean, most CFAs...
Yeah, well exactly, that's my point.
Yeah. But ladies...
I'm still struggling to see how the ability of the court to make some sort of a legal services order can be regarded as the same as a freestanding order for a success fee, which otherwise would be illegal.
But lady, it's a response to a point made by the appellant that there should be some public policy against putting the claimants in a better position, giving them some sort of perceived advantage in 75 Act claims. And the relevance of Section 5 for that argument is that it's already within the fabric of the Act that a claimant can have such a perceived advantage by being able to apply straight to the court for interim relief to fund, as the courts have applied Section 5 to fund legal costs.
Thank you. Has that point been determined at the level of the Court of Appeal?
Not as far as I know.
But that is the practice, is it?
That is the practice. The cases that are relevant to this are referred to, and I don't suggest that these are a completely exhaustive list,
No.
But the cases are referred to in our skeleton argument at paragraph 26.
Yes, I see.
The key authority is the decision of Mr Justice Mann in the Chancery Division,
Yes.
Smith and Smith.
Yes.
But there are others, and it appears to be regarded as a well-established principle by the first instance.
Yes. That may be a sufficient response to what might be called the broader submission made this morning, that there is a complete distinction between costs and awards under the 1975 Act. I can see, I think I understand your submission that neat distinction is not one which in fact is feasible under the Act. Is that what you're saying?
I'm certainly saying that although some commentators have suggested this, it's no part of my case that claimants can say to the judge, my financial needs include my legal bills, because the court has to apply the CPR, and the CPR deal with,
Yes.
I'm going to use the expression costs order. The CPR deals with inter partes cost orders.
Yes.
To answer a point made by my learned friend this morning, the CPR does not cover success fees. Now, she referred to some broad definitions of costs in Part 44, which is broadly worded. I accept to cover fees, expenses. You'll remember the wording. But Part 44 is a creature of statute. It's there to implement the wording of the statutes, and the statute says that success fees are not part of cost orders. So, in my submission, it's wrong to start by looking at the CPR in order to assess whether success fees are properly dealt with or should be regarded as part of a cost order. The statute is crystal clear now that they're not. And there's a slight danger here, especially for practitioners who practiced when it was possible to get success fees through cost orders, as it was for that period from the Access to Justice Act right up to the Jackson reforms. We have to change our thinking now that they simply cannot be part of cost orders. They are an expense incurred by a claimant in order to have access to legal representation. And that is as far as it goes. And the obvious points made throughout our submissions that is therefore a financial need. It is a liability. Financial need is unqualified within the Act.
So do you say that far from being against you, the fact that you can't claim it as part of the eventual costs order is actually a point in your favour?
Absolutely.
Well, it's critical to your case.
Absolutely. It's intrinsic to my case.
Critical to your case. But I'm not sure why you concede, necessarily, that there's a difference between other costs and needs. I'm not saying, well, I've got no idea what the answer is. That why can't one say, if one's focusing on needs include the cost of litigation, and that that if you're looking at needs independently of the cost regime, you're not asking what the costs are in accordance with the rules that apply under CPR 44 and so on. You're asking what are needs, and the needs are that providing it is a need and not just you can't afford the litigation unless you get money. So you've got Section 5 giving you interim money. I don't see why you necessarily accept that the only area of costs that would come within your purview, as it were, would be the success fee.
It's a dilemma that has been considered before. Andrew Francis, whose book, an extract from whose book appears actually in the authorities bundle, has formed the view, I only mention it because it's a text that many practitioners use, has formed the view that costs do indeed form part of financial needs, and that therefore claimants should seek to recover them. In practice, they don't. I don't think I've ever had a 75 Act claim where a claimant has asserted their legal bills as part of their financial needs. They may say in evidence what their legal bills are in order that the judge has a full picture of their cash flow situation. But I suppose the rather weak answer to Lordship's question is that as a matter of practice, claimants simply don't seek to recover them. And therefore, I suppose that's the mindset that practitioners are in. As a matter of pure logic and application of the Act, I can certainly see the argument that they should be recovered or claimed at least as part of financial needs. I suppose there's a practical difficulty in doing that, which is the practical difficulty referred to in part by Mr Justice Briggs in the Lillian case, which is that the court just isn't equipped until after it's given judgment with all the information it might need to form a view about the reasonableness of legal costs, certainly within the CPR, because obviously it won't have information about ADR and settlement offers and so on. And it would seem, because under the Act the court's got to consider the reasonableness of particular items of expenditure, I think the basis for the practice that there is that the CPR is the mechanism by which one assesses the reasonableness of those legal costs, and that therefore that's how they should be dealt with. But I entirely take your lordship's point.
I mean, I'm assuming
that's the only answer I can give to it.
Yeah. So I'm assuming if there's an interim payment for costs, that will be taken into account in any subsequent costs.
Yes.
And similarly, one might say that if one did treat costs as needs, and judges treated it very cautiously, as they're told to do if there's no clear statement of what will be incurred, that in general one would hope that it would be less than the costs that would ultimately be recoverable, and therefore
Indeed.
it wouldn't necessarily be to the detriment of the other party.
Indeed. But a difficult exercise,
Yeah.
perhaps.
But it's a difficult exercise, you have to accept, when you're looking at the success fee.
Yes, I do accept that. I do accept that. Although, by the time the court is considering that, it will at least have a view about the merits of the case, evidently, and it will have the information about the what I've described as the cash flow situation, that the means, the financial resources of the claimant. So it's an educated assessment.
So from a practical point of view, if the success fee is, as you say, to be part of the award, how do you say from a procedural practical point of view that that is to be done, given that the other side don't even know that you're subject to a conditional fee agreement?
As a matter of day-to-day reality in these cases,
Yeah, well, that would be nice.
if a claimant wants to claim a success fee as part of their financial needs, they'll have to say so in their initial letter of claim.
So,
They ought to be setting out.
and was that done? You
in
did
this
that?
particular case?
Yes.
I'm not aware that it was.
And what stage of these proceedings, going to our case, when did that all come out?
May I turn around?
Please do, yes. I'm fortunate you've got your junior with you.
Sorry, I understand it was fairly shortly before trial. I mean, a matter of days before trial.
And how was it disclosed?
It was disclosed in correspondence. I don't think those letters are in the bundle. There certainly isn't a complete set of correspondence in this.
Thank goodness.
Yes.
Oh, one might need to see those, however. And was it then on the schedule of needs that was presumably submitted to the court?
It wasn't in the written evidence of my client.
So none of it was in the written evidence?
It,
No reference in to a success fee within the...
Again, may I turn around? Yes. It was in correspondence, and then it was dealt with in oral evidence on oath in court. And it was on the basis of that oral evidence and the, I think, submissions made by the junior that the findings of fact were made in the judgment about the nature of the CFA.
And were the letters informing the court that this new element was to be added to the claim? Were those letters sent to the defendant? Nods down the row. Thank you. Yes.
I mean, I assume it came late in the day because of the judgment just a week or so before the hearing, is that right? Saying that these fees were recoverable? I wondered if that's what...
Indeed. The bullet and dentin judgment came out fairly shortly before. It was that created the
American Dental, 15th of April.
Yes, thank you.
My lady, I hesitate to interrupt. The email to the court is page 59 in the
Thank you.
supplemental bundle. It wasn't sent to my client until after the trial.
Not sent to your client till after the trial.
As far as I can see from the bundles, not till the 27th of April. That's on page 76.
I'm instructed that it would have been sent separately to the but I'm sure that we can dig out any relevant emails if you're happy to.
Sorry, page 15 is a supplementary bundle, was that?
Indeed.
59, sorry, it's 59, not 15.
There's another relevant email at page 69, tab 19, page 69 of that bundle,
Thank you.
which was sent by instructing solicitors, alerting the judge to the Clark decision, which of course went the other way, and making some brief submissions about why the reasoning in the Bullock decision should be preferred.
Again, I hesitate, but to give the court the sequence, page 68, so this is after the trial, the judge emails on the subject, and then this one comes in response to that.
In fact, the email at page 69 is expressly not a response to the earlier email. It says that they're going to respond to that by 5 o'clock today. It's my commission independently produced proactive email.
Comes after.
Referring to a judgment. I accept that chronologically it comes after.
Thank you.
And again, for completeness on this point, if you would turn to page 72, there's another email that was sent by Malone Jr. to the court. So the first one on that day was sent on at 9:41 that we've just looked at. This one is sent at 2:16 in the afternoon, and it deals first of all with a point about housing raised by the judge, and then over the page, halfway down, you'll see a number 2, and there's some further submissions there about.
Sorry, just I need to catch up here a bit. From Sophia Rogers, yes.
That's my junior.
Yeah, I appreciated that. And this is sent to
Karen Selby
King.
who I think is the judge's clerk.
But all this ex post facto submissions and argument, the defendant wasn't copied into any of it. Can't be right.
I understand that it was forwarded separately to those emails.
It's on page 76, is when it's forwarded. But it appears only to be the post-trial material that's forwarded.
But, Milady, one of the points that's made in the long email from Ms. Rogers at the foot of page page 73 is that it's noted in the last couple of lines that the claimant started the proceedings claim on a private basis, but confirmed during live evidence that she didn't have enough money to run the claim through to trial and had no choice but to enter into CFAs. So that's just the reference, that's the only reference there is in terms of live evidence that was given. And then at the first hole punch over the page, at page 74, says in the present case information has been provided by those instructing and confirmed by the claimant in live evidence regarding the CFA agreements entered by her with solicitor and counsel. Detailed information has been provided by those instructing regarding the level of incurred base costs and the liability up to the date of hearing. And then she says at the very end, I'll ask those instructing to forward a copy of this email to Mr Hirachand. Malone Jr. informs me that these emails were sent directly in response to a request from the judge for clarifications.
Wow.
For the purposes of section 3(5) of the Act, the judge was therefore taking into account the facts as they were at the date of the hearing. And I accept that information about that element of financial needs came out very late in the day. But
It was substantially argued after the trial.
but the fact of the CFA was there at the date of the hearing, and hence formed part of his judgment. There are some points made by Deputy Master Linwood in the Clark case that I'd like to respond to briefly. I'm conscious of the time. I'm going to be fairly brief on this because our skeleton, I hope, is fairly full.
It is, and most helpful, if I may say so.
Well, I hope I won't just repeat it.
You can take it that we've
please
read and
stop me if I
reread.
do. But
You want to take us to Clark, do you?
I'm not sure I need to. If I can just state a couple of principal points briefly. There are a couple of references in Clark to damages claims, and a point it's hard to argue with, that damages claims don't include costs. But there's a stark difference between damages claims, where the claimant is seeking to recover for a particular loss caused by breach of contract or some form of tort, and the comprehensive review of a person's individual but global financial needs that the court is carrying out in the 1975 Act case. So I don't accept that looking at damages claims is the appropriate way to look at success fees in this context. As far as ADR is concerned, which is another point made by Deputy Master Linwood, a CFA-funded litigant on either side may have a slight advantage in that they may not be so concerned about the monthly legal bills that they might be getting, assuming it's a complete no-win, no-fee agreement. But on the other side, it could be said that beneficiaries who have access to funding from an estate, assuming that the estate's more than large enough to cover the top end of the 75 Act claim, may themselves have an advantage against an impecunious claimant. So it's not inevitably a one-way advantage to have CFA funding.
I think that slightly runs into some difficulties with your argument a few moments ago about the advantage you've got in applying for interim remedy.
Well, Milady, it depends on the particular case. You can't apply for an interim remedy if there there is a estate that consists of shares in a family company that may be creating dividends that the beneficiaries have access to, but you cannot liquidate, you can't realise it sufficiently quickly to create into relief for a claimant. Every case will depend on its own facts, but there could be advantage on either side depending on the particular case. CFAs tend to include, certainly the standard chancery one does, a term that the lawyers will cease to act if the client doesn't accept a reasonable settlement offer. So there is always going to be some element of pressure upon a CFA-funded claimant to act reasonably and to engage in ADR reasonably. And in terms of the figures that will be on the table in any form of ADR, generally speaking, the success fee will form a very small part of those figures. So, and is up for negotiation just as much as costs are within a mediation or any other form of ADR. So it's more nuanced than was suggested by Deputy Master Linwood in Clark. I think, lastly, can I just make a point about maintenance? Maintenance is an exceptionally broad term. My Lord Sir Patrick referred to the words "or indirectly." I think it was Sir Patrick who said it in the Dennis judgment that's been cited in so many other cases since, including an ILOT. What the court is generally looking at in maintenance-based claims, especially for somebody with potential earning capacity, is enabling them to earn their own living. And that's exactly what was done in this case by award of the success fee. Because what the judge was trying to achieve was enabling my client to go back to work. And he finds in the judgment that she needed about 3 years of specialist therapy in order to be able to achieve earning capacity again. And that in order to be able to discharge the costs of that therapy, she clearly would need not to have the burden of paying the success fee to her solicitors. So that is how the success fee directly feeds in to the maintenance. The cases that Malone and Friend refers to do not dislodge the principle that payment of a debt can amount to maintenance, and I've explained why in the Scottish argument, that I think I'm probably running out of time to say much more about it. Can I, before I sit down, double check, because I think there were one or two things I needed to just cover. Part 36. Rule 36.17 deals with the consequences following judgment of not having beaten a Part 36 offer. Whether it's a claimant's offer or a defendant's offer that's not beaten, the court has a reserved power to not apply the automatic penalties in Part 36 if it considers it unjust to do so. And one of the reasons why it might be unjust to do so is the extent of information and accuracy of information that the party receiving the offer had during the 21-day period it had to consider whether or not to say yes or no to the offer. So inevitably, if a claimant has been silent about its success fee, or indeed any other financial need, and then it only emerges after the date of an offer, then it'll be difficult to persuade a judge that, to the extent that that need affects whether or not an offer should have been accepted, it'll be difficult to persuade a judge that Part 36 consequences should apply. So Part 36, in my submission, actually adds very little to, if anything, to to the submissions I've already made about the positions within ADR. I think, unless I can assist your ladyship and your lordship's further, that concludes my submission.
No, thank you very much indeed. That's most helpful. We will, of course. I'm conscious that you felt slightly pushed for time, but I can assure you we've got your skeleton. No, not at all. You're very welcome.
Appreciated, by the way.
Our pleasure. Doesn't matter at all. And we have got your very extensive skeleton argument. Anything in reply?
Very quickly, my lady, my lords. The learned friend indicated that no one suggests that the appellant couldn't read the documents she received. The handwritten letter she wrote to, it's addressed to my learned friends instructing solicitors at the end of January 2020, which is in the supplemental bundle, page 50, although we can see from page 49 it wasn't sent until very shortly before the trial, does say that she cannot read. And that's the one, my lady, where one tracks the chronology. It appears to be the updating witness statements that were sent shortly before. And of course, we have, my learned friend has highlighted the witness statement from the solicitor Vickers, who said he was having to use a screen to enlarge and to show her. Suggested that this letter was her trying to participate, send written submissions to the judge. I simply make the point, the letter was sent to the judge ultimately, but it was addressed to the solicitors some months before the trial, at the end of January. I'm grateful to my learned friend for highlighting the practice direction which has been added to CPR 1, looking at, because I was mystified why I hadn't seen it before, looking at page 61, Rule CPR 1.6 incorporates the practice direction. It was introduced on the 6th of April this year, so I'm not feeling quite so bad when I originally looked at this matter. I hadn't seen it. So perhaps there's some hope that the civil jurisdiction will start to catch up with the fellow jurisdictions. My learned friend suggested that we are not by the appeal on ground 1 seeking a retrial. That is our primary case.
Yes, we know.
I acknowledge the difficulties there. It was suggested that the executor, the son of the appellant, could have been invited to defend the matter with the benefit of an indemnity. The huge problem there would have been that without resort to Section 9 of the Inheritance Act, the severing of the deceased's interest in the joint assets, then it would have been a situation where there was very little in this estate, significantly less than what was claimed. Indeed, on the face of it, the amount, as the judge pointed out, the amounts claimed exceeded even with the Section 9. Section 9 makes it very clear that the severed interest or parts of it can only be taken in order to go out as reasonable financial provision. So they wouldn't have been capable of being used to provide the indemnity. So this executor would have been looking at an estate knowing it was very unlikely, as far as the estate was concerned, that actually there would be enough there to protect him had he stepped up and challenged the claim. My learned friend also pointed to the draft order for costs and said, well, the executor agreed. Well, of course, he couldn't agree on behalf of the appellant, my client, and why wouldn't the executor at least indicate he had no issue with an order for costs that wasn't coming out of the estate. So opposition is that really doesn't add anything. So far as the position on the conditional fee agreement and the success fee is concerned, my lady, my lords, we would say that the tension identified by Mr Justice Briggs in the Lilyford case is exactly confirmation of the position as we put it forward. He was identifying that the Inheritance Act jurisdiction is driven by needs, but unlike the jurisdiction in family proceedings, the costs regime is not geared to addressing that and to giving the necessary information and mechanisms to enable the court to deal with the matter holistically as it can in the family division. And in particular, he was referencing to the difference in terms of open offers as opposed to secret offers. That is exactly what we are saying here. The civil costs regime is not one that means you can dip into or recast the nature of costs and ignore the regime and the statutory restrictions that exist so far as costs in order to facilitate an Inheritance Act provision. So far as the Section 5 relief is concerned, my lady, my lords, to be clear, the language of Section 5 is very different from the language of Sections 1 to 3. Section 5 is about immediate financial assistance, and it fits very well with Mr J's description in the family context of the way an interim order should be used to deal with future costs that would otherwise lead to someone being denied access to justice. That is how the courts have used Section 5, immediate financial assistance. That is very different from an award providing reasonable financial provision defined as it is by the Act. The language is different in Section 5 from the rest of the Act, which is concerned with dealing with the needs in these types of claimants for such reasonable financial provision for their maintenance. Maintenance doesn't feature, the language of reasonable financial provision doesn't feature. It is just a facility for the court to provide immediate relief on the journey and is being used in exactly the way Mr J describes on page 324 that my learned friend took you to provide that assistance with the future need, and he warned that it should not be used to subrogate as a surrogate for inter partes cost jurisdiction and should not be used as a way of awarding cover for historic unpaid costs as opposed to future costs to allow someone to continue with litigation. And that's exactly, sorry.
Sorry, no, you finish, I'm sorry.
That's exactly what the respondent was inviting the judge below to do, and he did.
But might a claimant be in a position where they're not able to afford litigation, and they may have the option of either a payment under Section 5 or perhaps entering into a success fee agreement? Is that realistic? And if so, is it justified in distinguishing between them?
Yes, there is a justification for distinguishing between them. They're very different events. One is upfront, in anticipation. The court and everyone else knows what's happening, and the court at that point, before the conclusion of the matter, can deal with it. The other is a private contractual commitment that is made, where the uplift, the additional bit of the fees, is something that Parliament has said you should not be able to pass to the other party.
And with the
One
same-
is court controlled. The other, yes, there are ways in which the court can influence it, but what effectively the respondent says is, when I then come to the court at the point of the award and you, the court, have decided at trial that I do have maintenance needs that need to be met, if I say, well, and now I can't afford to pay this bill, this private contract I chose to enter into that has this extra provision that Parliament has said should not be shunted onto the other party, you should effectively achieve that by adding it to the award.
I think what's being suggested is that it might encourage parties to go by way of Section 5 route, because they will get, if their needs are strong enough, they will get litigation paid out of the estate come what may,
Indeed.
rather than go down the CFA route, which, if you're right, would leave them in a significantly worse position, potentially.
My Lord, what it would encourage is, yes, potentially for them to go that route. Yes, then for the ultimate cost bill across the case not to include an uplift, and for everyone to know exactly what's happening and for that to be dealt with before it's happened, as opposed to being presented as a fait accompli at the end.
But do the same rules or procedure and approach apply under this Act as in financial remedy proceedings? Because you absolutely will not get a legal services order if there's any other way that you could get the money. So note CFA doesn't apply in financial remedy cases, but it says tooth agreements do
Indeed.
apply, and you just simply won't get the order if there's
There
any
is-
other route.
My lady, I was careful to say Section 5 is being used in that way, whether it's an appropriate use and whether it is being controlled and approached. It doesn't have the structure around it that exists in the family proceedings. And what is unfortunate is that the Inheritance Act is a jurisdiction that operates differently to most claims in the civil proceedings, but it sits squarely, so far as costs are concerned, within that context. And indeed, as you rightly point out, CFAs are not an option in those other proceedings for a whole range of reasons. But in relation to Inheritance Act, they are. And we would say there is no reason that having chosen to use a CFA in Inheritance Act proceedings, the claimant in this case or any other should be in a better position than any other claimant in civil proceedings who chooses to use a CFA. Those are all the points I was going to make.
Thank you very much.
Sorry that
indeed.
we have taken your day.
No, well, it's been extremely interesting, and these are difficult issues which need a considerable amount of thinking about. So you won't be surprised to hear that we will reserve our judgments. I can't promise you exactly when they will be handed down, but as soon as reasonably practical, and hopefully before the end of term. But that's not a gold-plated promise.
Understood, my lady.
We'll send them out in the normal way for typographical and any minor grammatical or factual errors. Obviously, not an invitation to re-argue any of the matters that you've dealt with today. I anticipate it will be handed down electronically, given the current provisions, and hopefully any other matters can be dealt with in writing as far as any costs issues that arise, and hopefully you can agree an order between you in due course. We'll deal with any further disputes in writing, and there's no need for any further attendance in court. So can I thank you all very much indeed for all the hard work you've put into the preparation of the case, which has been very helpful. I'm particularly conscious. I think Miss Rogers was a counsel at first instance, but I don't think Mr Ingham was. Were you?
No.
My lady, no, I did appear before Mr Justice MacDonald on one occasion, but I was not instructed at all after that.
Thank you, but I think special thanks goes to Ms Rogers, because it's always extremely helpful in the cases of this type when we do have the benefit of counsel that's present at the hearing to assist all of us. Thank you all very much.
Thank you, my lady. Thank you, my lords.